Okay, hi everybody. This is Conn Maciel, and with me I have my partner Jordan Schwartz. Welcome to another webinar in our Labor and Employment webinar series for 2017 on key employment law issues for startups and other small businesses, including some relevant California law. We always have to take into account that crazy state that's its own country over on the West Coast. I want to go over a little housekeeping before we get into the nuts and bolts of the presentation. As you may have heard, this webinar is being recorded, and we will be able to make both the recording and the slides available to everyone who's participating today. So no worries about, taking down everything that's on the slides. We'll be able to send these to you later this afternoon, and you'll be able to share the recording and the slides with anyone else in your organization who may have missed it or who you think may enjoy the webinar. This is also, because we have everybody muted, it is a conference call webinar. Everyone is being muted, but if you do have a question, feel free to type it into the chat box, and we'll either try and answer the question as it's being coming in, or we'll have some time, hopefully at the end, to answer any remaining questions. But that's the best way to post your question. And then, as I mentioned, this is a webinar series. We hold these webinars, which are complimentary, about once a month. And so if you're interested in attending future webinars, we'll have a slide at the end that goes through all the future topics and the dates, and we encourage you to register for the rest of them as you're available. So with that, we'll jump kind of right into the topic. Jordan and I are both partners here at Conn Maciel Carey. We founded this boutique labor and employment firm a few years ago, and we focus specifically and exclusively on labor and employment issues for businesses of all sizes, in particular startups and small businesses, and really do the gamut of counseling on the A to Z of the hiring process, employment relationship, all the way through termination, as well as defending companies and employers in litigation, as well as doing training, sexual harassment training, diversity training, other types of trainings for employees, and other programs. So with that, we're going to get right into kind of what today's topic is going to be, and that is, the fact that when you've got a startup, business owners and entrepreneurs really typically focus their time and energy on starting, developing, and financing their core product and service. I certainly can attest to that. When we founded this firm, we spent a significant amount of time, focusing on the type of culture we wanted, who we wanted to bring on, how we wanted to differentiate ourselves in the marketplace from our competitors. But we also needed to realize that we would be hiring people, and so we had to focus some effort on the importance of having all of those ducks in a row the minute that our business launched. And that's the same thing for you. It's really important not to overlook compliance with various state, local, and federal employment laws when starting a business, because failing to comply with those really could reach out and lead to substantial cost, or even risking the entire joint venture or business venture if you don't have the right operating agreement, for example, in place, or shareholders agreement, or you didn't file the right forms with the state agency to hire and employ people within your location. So the goal of this webinar today is really to talk through a lot of those issues at a summary level and the primary areas you should be concerned about from an employment law perspective. So the first thing you do, and it's the first order of business, is hiring your employees. And before that, you need to comply with the number of filing and reporting and insurance requirements that may be in place in your location. In addition to federal requirements, which would include your W-4s, your tax forms, your immigration forms, workers' comp issues, states also require businesses to report information about their employees, including maybe your wages, or how often they're paid, or if they're considered exempt or non-exempt from overtime. So those are the kinds of things you need to be aware of before you even hire your first employee, and we'll talk about some of those specific requirements. So, starting out, you're going to want to obtain a federal employer identification number from the IRS. This is really easy to do. It takes 5 minutes. Go right on the IRS website. You get your FEIN number. You'll use that FEIN number for a number of important federal documents, including your W-4s that you submit and your employees are required to complete on their first day. So you've got the federal form, which talks about how much payroll and pay has to be deducted. You're going to have the equivalent state form as well, and depending on where you're located, it might be multiple states. For example, here in the Metro DC area, we've got employees that fill out a Virginia form, a Maryland form, and a DC form. So be aware of not only where you're located, but where your employees reside in terms of where they might want their state taxes deducted. You also want to look at your locality because, as I mentioned earlier, there might be some type of hire reporting that's required in the state of employment. And this is true, as I said, in several states, New York, California, and DC including, again, mentioning who the employee is, how they're classified, and sort of how ultimately they are going to be paid. The other thing you want to make sure you have is your employees completing an I-9. The Immigration Reform and Control Act prohibits you from hiring employees who are not legally authorized to work in the United States. There's also, strict visa requirements to the extent you have someone who is coming, from overseas. If they have a particular skill, that is a big subject of discussion right now at the federal level in terms of the federal government restricting the number of available visas. So you want to make sure that you're working with competent and strong immigration counsel if you are bringing over anyone from overseas. But assuming not, you're just hiring workers who are authorized to work in the United States. They need to complete an I-9 eligibility form by the first day of work. Not necessarily, again, the first day of when they accepted the offer. It's really their first day of work. And then Section 2 has to be completed within 3 days of hire. So you want to make sure whoever's in charge of onboarding that they have a very good packet of forms, including the I-9 forms, and that they're trained on how to complete those forms. What kind of identification is allowed to be submitted? What does that document, the IDs look like? How do we tell in good faith that they are valid and true documents? That stuff requires, some sophistication, and so it's important to make sure that whoever's in charge of hiring and completing out that information and signing those forms on behalf of the company is making good faith efforts to establish that the documentation is valid. Then after, of course, someone starts, you've got payroll. They're starting to come on board. They're performing services for you, and even if they work one day, they're going to be entitled to payroll. So you want to talk about who's going to be responsible for payroll. Is that going to be a chief financial officer, a human resources professional, some other payroll company or third-party professional employer organization? Kind of think through those issues as you're planning and figuring out who's going to be responsible. And then get to how often are you going to pay your employees? Will it be weekly or biweekly or monthly? Some states have specific requirements on that with respect to non-exempt employees, and so you want to look at that. And then you also want to figure out how they're going to be paid. Are they going to be paid on a salary basis? Are they going to be paid hourly basis, commission basis? All of those factors, again, a lot of times that has to be disclosed to the state reporting agencies, so you'll have to figure that out in advance. And we recommend that you include that information to the employee in an offer letter so that it's perfectly clear, fully understand it before they started, how they're going to be compensated and what is included in that compensation. If they're going to be paid salaried and they're exempt from overtime and you expect them to work 45, 50 hours a week, I would make that clear up front. If you somehow have a commission basis, you want to make clear that how those commissions are going to be detailed and paid is made clear so that there's no miscommunication after someone has already started working and you've got all those details ironed out. And importantly, you want to make sure that your pay practices are well documented and that you're maintaining the right records that you need to under federal and state law. Jordan's going to cover the second half of the program on wage and hour issues specifically because that tends to be the most expensive and costly risk of exposure for new businesses and small businesses. So I won't get into detail with that, but know that this is a really important part of making sure that you are protecting your business, taking advantage of a safe harbor defense for certain wage payment errors, and other issues. So then, once you've kind of got these initial federal law form issues worked out, then let's talk about, hiring and interview and some risks that we often see small businesses run into in terms of the hiring process. So be aware that, you've got exposure from, either discriminating or retaliating against someone based on someone's protected category, hiring an employee who, if you're in the tech business or in sales, for example, who has a non-compete or some other restricted covenants from their prior employer. Be aware of, ask for those agreements up front so you know if you're opening yourselves to risk. Think about immigration issues, again, wage and hour violations that Jordan will talk about, the importance of background checks and social media. All of this runs the typical type of exposure that an employer may have to hiring. We've got a question in terms of how does one determine whether an employee is hourly or salaried. Jordan will talk about this later on in the presentation, but that really goes to the essential determination and legal conclusion whether someone is exempt from overtime. If someone is exempt from overtime, they have to be paid a salary, a fixed salary. Otherwise, if they're not salaried, they can be paid hourly. Even non-exempt employees can be paid a salary. So it really is more a determination of exempt versus non-exempt in that characterization. And Jordan will discuss those specific allegations. And then Section 1557 of the ACA, that applies, as you know, to employers with 50 or more. So we can talk about that depending on the size of your business. Other areas of recruiting that could trigger discrimination claims. You've got, the way that you recruit, use of technology. Super easy to, again, use social media or use the internet to look at individual. Most federal anti-discrimination laws don't apply to businesses with fewer than 15 employees, but some state and local laws would cover those, even small sizes, even if you've got an employee of one. So just be aware that while you may not be an immediate target of a plaintiff's counsel or the EEOC, as you grow and gain public recognition, the risk of these types of challenges increase. I mean, just look at the startups of Twitter and Uber and Facebook. They've all been faced with some type of discrimination, whether it's gender or pay or other issues as they've grown. So just be aware of that. And ways and proactive defenses that you can implement. The ways you minimize the risk of a claim of discrimination or otherwise is understand, again, your federal, state, local level, and the protected categories. Some states are much more expansive in the types of protections that they include. For example, you might include in D.C. marital status. Even political affiliation in D.C. is covered, where it would not be covered under federal law. Gender identity and sexual orientation is a growing area of expanded protections. So be mindful of where the courts and where your jurisdiction falls in respect to that type of claim. And importantly, just make sure that individuals in the hiring and recruitment process are trained to identify and avoid those practices, not to ask the wrong types of questions during an interview. Have the right employment application, making sure that you're identifying the right functions and job duties for the position, and that you're hiring based on those job duties. And that if you have a job description that needs certain physical requirements, such as a lifting requirement or other types of physical issues, make sure that those qualify and meet issues under the Americans with Disabilities Act. So just importance of training and identifying and understanding where you can best protect yourself. And then in the interview itself, the best thing is just to focus on objective criteria on the individual, not how they, what their accent is, but whether they communicate effectively, whether they present themselves well in a business environment, not necessarily how they dress, for example, for the interview. Different ways in which you evaluate someone's qualifications that wouldn't potentially open yourselves up to a discrimination claim. And as I touched on briefly, social media issues in hiring is still very developed. I know it's integral to startups and small businesses because it's such a primary tool for the way that you communicate and you gather information, both for owners and also employees. I mean, the employees that are coming to work for your company are using the internet to research you, whether it's glassdoor.com, LinkedIn, or other news sites about what's going on in your company and where you're growing. Equally, too, we get calls and concerns from HR saying that they want to use social media. Time and time again, I'm getting a call that, we had an applicant come in, the person looked really good, their resume was great, but then I Googled him afterwards, and I happened to find a news article that says that he was involved in some kind of wrongdoing a couple years ago. Well, you didn't really run a background check, you just Googled him, and who knows if that's the same person, who knows, whether those charges were dismissed, who knows, we can't trust everything that's reported on the internet. So it's very difficult to take those issues into consideration. So be very cautious about whether you're going to use social media and how you can effectively use them in your recruiting. I have no doubt that, organizations like LinkedIn is completely underutilized for purposes of recruiting quality top talent. I think there is so much opportunity there for businesses to be able to use, again, something like LinkedIn. But if you're going to use social media to select and particularly to weed out potential candidates, that's where we could run into employment law issues and what I want you to be mindful of. So just understand that you want to, be cautious and really seek counsel with respect to how you're going to use social media. In addition, you may want to consider doing a background check. This can be really helpful to learn a little bit more about their job history, for you to do employment verification checks, their credit history, if that's permissible by state law, personal character. You always should call references. Sometimes they won't disclose anything other than last date of employment, their title, their salary, whatnot. But still, I think it's important to understand and call references because it could open up and protect you from potential legal exposure if you were to make a bad hire. Often companies use a third party to do background checks, and there's a number of them around the country that do these. That's known as a consumer reporting agency, and so there is a federal law that has to be complied with respect to how you're going to do those background checks through a disclosure requirement and seek advanced consent. That would be part of your onboarding and application documents that you'll want to prepare if you do use a third party to conduct those background checks. And the type of background checks, again, as I said, could be just past references, but you might want to consider a criminal background check or a credit check based on the nature of the job. Most of these states are starting to pass what we call ban-the-box laws, and it's prohibiting you from doing either a criminal or a credit background check before a conditional offer of employment has been made. So really be important to check your state there. But for example, if you are allowed to do a criminal background check after the offer of employment is made and something comes back that is a hit on their criminal history, you want to look at some factors like how long ago did it happen? Is it related to the job in which they're hiring, or is it totally unrelated? Maybe it's a DUI and this person happens to be in telephone sales and they have no duties to be on the road. Or is it something that does have more applicable job, a bona fide job, qualifications, and therefore could be considered a reasonable basis for you to deny employment? The most important thing is you can't have an automatic ban denying employment based on someone's criminal history. You've got to consider it on a case-by-case basis. And again, this would be another time to seek out good legal counsel. In terms of credit history, that also is all over the map. Some jurisdictions outright ban doing a credit history unless you are a bank or a financial institution. That's the case here in Washington, D.C. That's also, I believe, the case in New York. Other states like Maryland allows you to do a credit history, but only if you've got a bona fide job tie to the job duties. So it would be someone who's involved with financial dealings for the company, your CFO, your accountant, or let's say you're a payroll company and you intake information from your customers, again, payroll information. And so you've got social security numbers and bank account numbers and all, highly personalized, sensitive information. Individuals handling that kind of data would be eligible to have a credit check run. So for there, just reiterating, check your state and local law, but in any event, it needs to be really tied to the type of job functions that individual is performing and not just a blanket ban. So we talked a little bit about this in terms of the Fair Credit Reporting Act. Before you are able to obtain a consumer report or a background check, you have to notify the applicant that you're going to obtain the report. You've got to obtain their consent. And then to the extent that something comes back, there are specific obligations in terms of how you notify that individual if you're going to take an adverse employment function. California, as I said, also has restrictions on background checks. Generally, California prohibits employers from asking applicants to disclose an arrest or detention that did not result in conviction. That's certainly true under federal law as well. The EEOC takes that position. And you can't look into juvenile or court proceedings, and so be very cautious in using any of that information in any type of employment decisions. So the best thing to do here with respect to background checks, credit checks, or how you're going to do that is, again, make sure your application, to the extent you ask for an employment application, that it does not have information about disclosing arrests or convictions beyond a certain number of years, or even ask that information at all, because again, some states you're not allowed to inquire into their background until after a conditional offer has been made. Making sure that your managers are trained and they understand at what point, when, and to what extent they can ask for that information. And then to the extent you have ongoing background checks for your employees once they're hired, and let's say they're in a financially sensitive position, and you're doing ongoing, recurring annual background checks, you want to make sure you have a company policy in your handbook that identifies and discloses to your employees that as a condition of employment, they will be subject to periodic background checks, and that's delineated on how. So some other documents you want to think about are, your basic employment documents. Do you want an employment contract, or do you want to have your employees as at-will employment? I hear a lot about at-will. At-will simply means that you are entitled to hire or fire an individual for any reason, just so long as it's not an illegal reason. You don't have to provide any notice period, for example. Whereas an employment contract, this might be something you might want to have for your more senior level employees, maybe sales, people that have information that you want to protect and retain. So you do include maybe a notice period. They have to give 2 weeks notice or a 4 weeks notice if they're going to leave the company. Or you put some restrictions on the ability for you to separate the employment and for them as well. So think about that based on the nature of your business. Other onboarding documents, we talked about the offer letter. Think about maybe you want to have a non-compete or a non-solicitation agreement. If you, again, are in a growing entrepreneurial company and you want to protect your core product and your core service, that would be a key document to consider for your sales or your chief development officer or technology officer, things of that nature. For all employees, you might want to consider a confidentiality and non-disclosure agreement, that they can't take your company's secrets and use them to the benefit on their behalf in the future for subsequent employment. Also, arbitration agreements. There's been back and forth on arbitration agreements for years, and I think the tide has finally shifted back to the pros of an arbitration agreement, particularly because we believe the law is going to quickly allow employees to waive class actions, wage and hour class actions, or other employment-related class actions, waive their ability to participate in class actions, and instead be required to arbitrate those on a single case basis. There's a case that's pending before the U.S. Supreme Court that we expect to be heard later in the fall. And in reading the tea leaves, we think that the Supreme Court will uphold the employer's rights to allow employees to waive a class action and arbitration agreement. So that might be something that could save you a lot of money going on down the road, and require, to the extent you have subsequent employment disputes with your employees, to arbitrate them in a fashion that might be less costly than formal litigation. Think about, too, your formation documents, your articles of incorporation, and importantly, decide in terms of having an attorney draft those documents, because you and your best friend may have just started a great business and you've got a handshake agreement, and in 10 years you make $100 million and something goes wrong. If you don't have the right formation documents that were drafted at the very, very beginning of the venture, it could be significant for exposure. Workplace postings, be aware if you have a payroll company, you want to make sure you are posting the right posters to make sure that employees understand what their rights are. Most of these can be provided by an outside third-party payroll provider. You could even do it electronically if you don't have a central office, or even by email. One of the most important things that a growing business should have is an employee handbook. I know a lot of very small companies don't do that, or they use a canned handbook that they found on the internet or through a payroll company. But as you grow, it's very important to make sure that you have a set book of policies and procedures that are legally compliant with your state and local laws, and that establishes your company's culture. It really helps prevent litigation. If you're over 15 employees and you're subject to Title VII, you need to have a policy against sexual harassment, because if you have that policy in writing and you've distributed it and you've got training on it and employees are aware of it and they do not take advantage of that complaint protocol, that's a big defense that you have to defend against any potential harassment or discrimination claim. So there's some real advantages to protecting your company from future liability to having that handbook, and one can be developed pretty easily and efficiently. Even if you want to use one from your payroll company, having a quick legal counsel review of it should not cost a lot of money, and it absolutely is a really good proactive step to avoid a costly exposure down the road. Paid time off, this is sort of the last kind of area I'll cover before I turn it over to Jordan to cover wage and hour issues. But paid time off is another big area and hot topic for companies as you're growing. A lot of companies, like to provide different benefits to attract the millennial culture. It might be paid gym memberships, again, catered lunches, happy hour every Thursday or Friday. But think about also the time of vacation and time off, because the concept of this work-life balance issue is very attractive for individuals that are looking to join your company. And so think about how those perks will be paid out, how they'll accrue, and ultimately what employees are going to be obtaining. When you've got a paid time off, a PTO bank, that basically means you're going to accrue a certain number of paid days each year. Some locations require you to have paid leave, sick leave or paid leave. That's, again, a growing area. Other states are silent on the issue. Federal law is silent, so it allows you to determine how much of accrued leave you want an employee to have. Then when someone leaves, either they resign or they're terminated, the employee then is typically paid for unused and accrued paid time off, unless you've notified the employee in writing in your employee handbook otherwise, that is forfeited, for example, if they're terminated with cause. Some companies are exploring a concept of an unlimited vacation policy, and that allows you to say you take the leave when you need it. We're not going to count it, but it doesn't go with you when you leave the company, and so that could relieve a financial burden on you if you choose to do that. In California, as I mentioned, some states mandate paid sick leave, and California is one of them under the Healthy Workplaces, Healthy Families Act. And so all employees, including temporary and part-time employees, are entitled to paid leave. And employees who've worked at least 30 days in California, even if they don't normally reside in California, if they work, some portion of their time in California for your company, they also can be considered covered. Generally, the types of leave that can be given is diagnosis and treatment of health conditions of the employee or their family member, preventative care, and more recently, time off for victims of domestic violence, sexual assault, or stalking. Oh, I have one more topic that I forgot to mention, and that's finally, before I turn it over to Jordan, equity incentive plans. Offering equity, is a really good way for you to attract top talent depending on the nature of your business. But just be aware of, again, how much you want to divide among your employees. This is something that the C-suite executive should really think through carefully, and then be able to have, concrete answers in developing and drafting those documents if you're going to do that for the talent that you're recruiting. So with that, I'm going to turn it over to Jordan, who's going to start to talk about wage hour law and how that impacts your business. Jordan?
Thank you very much, Kara. Nice to speak to you all here. And as Kara said, we felt like wage and hour law is such an important issue that we really devote virtually half of this presentation just to these very issues, since wage and hour law kind of encompasses a host of different issues that I'll explain right now, and really can get you into trouble. And unfortunately, sometimes all companies, and especially some startups and small companies, don't really realize the implications that simple violations of wage and hour law can have on your finances and even on your very existence. So I don't really mean to scare you here, but I just really want to make you cognizant of the different issues that arise when starting a company from a wage and hour perspective. And really, the most important thing I just put on the first bullet point right here is, it sounds obvious, just make sure you comply with your minimum wage and overtime laws. And the first way you do that is know what the actual minimum wage currently is. The federal minimum wage right now is $7.25 an hour. For the most part, that ends up being irrelevant because most states have a separate minimum wage that's higher, and under the law, you have to pay the higher of the two minimum wages. So it's almost always the state minimum wage, unless you're in a state that doesn't have a separate minimum wage, and then you just pay $7.25 an hour. I just threw in two examples. We're located in D.C., and here it's $11.50 an hour. And in Maryland, right this minute, it's $8.75 an hour, but in 3 months, it's going to increase to $9.25 an hour. And many states also have this where once a year, either in January or after 6 months in July, the minimum wages increase. And what I typically find with our clients is most companies are paying minimum wage, but it's when overtime comes into account that this all gets complicated. And the general rule is that non-exempt employees, essentially hourly employees, and I'll explain the difference in a minute, must receive an overtime premium pay amount of 1.5 times their regular rate of pay for all hours worked in excess of 40 in a work week. And I will go a little more detail later about regular rate of pay and what that means. It is not only 1.5 times their hourly rate. It may be if the employee only gets paid by his or her hourly rate, but typically there's some sort of bonus an employee receives, or some sort of commission, or maybe he got paid for training time at a different amount. If there's any other amount in addition to the straight hourly time that an employee is paid, that has to be factored in, and you need to figure out what the actual rate is, which will typically be higher than just merely the hourly rate. So what a lot of companies who are starting out decide to do, and it's seemingly a good idea at first, is the thought process goes like this. there's so many complicated wage and hour laws from an employee perspective. We have to deal with discrimination laws, a lot of unpleasantness. Why don't we just utilize independent contractors? That'll save us not only monetary costs, it'll also just save a lot of headache and hassle. They can take care of their own taxes, and we just kind of wipe our hands clean of all this. And as I said, to classify workers to avoid potential lawsuits and penalties by the Department of Labor has some good merit in theory, and it may appear that it could save you costs, at least in the short term. But if the worker is actually an employee, it will not save you costs. It'll end up causing you a lot more headaches to reclassify, potentially get penalized. And what you want to do if you're considering going down this route is really consult with legal counsel and determine if your workers could possibly be considered independent contractors. Most likely, if the worker is working solely or even primarily just for your company, at least at this juncture, what the Department of Labor has said is that employee is that worker is most likely an employee and cannot be considered an independent contractor. So there's really two majorly important factors, although there's a whole host of factors, and I'm not going to have time to get into all the factors. But one, if the worker is primarily employing work for you, and two, the amount and degree of control that the employer has over the worker. And the more control an employer has over the worker, the more likely it will be considered that the worker is an employee. In the past 8 years, the DOL has really strongly scrutinized independent contractor relationships. There has been what's called a misclassification initiative between the Federal Department of Labor and various states. At this juncture with the new administration, there may be it looks like there will be some decrease in enforcement. However, that doesn't mean all of a sudden these laws regarding independent contractor status can just be nullified and thrown out the window. So I still urge you to be very cautious and remember that any potential tax benefit of using independent contractors is outweighed by the cost of legal exposure for back wages, taxes, overtime, and other penalties. But if you decide that independent contractor status is actually appropriate, it is just key, and I want you to remember, to memorialize the terms in a contract. While that is by no means determinative, it's certainly more advantageous for you if you have an independent contractor agreement than if you do not have such an agreement. The other area here where the word classification gets thrown about is with employee classification. So now we're taking independent contractors off the table, and we're assuming you were just using employees. Now you might want to determine, should they be exempt or non-exempt? And essentially, while it's not quite this simple, I'm going to say exempt is salaried and non-exempt is hourly. And what some employers, especially starting out, may think is, you know what, it'll save costs by treating most employees as exempt. We'll just pay everyone a salary. That way, we never have to worry about overtime payments. And you know what? There's no uncertainty. We can really budget easily. We won't have to wonder about how much our payroll is going to be. And again, as with independent contractors, theoretically that makes sense from a budget perspective, from a planning perspective. But unfortunately, that's just a huge risk from a misclassification perspective. You need to determine, and I will give you the test in the next few slides here, whether someone truly is exempt, and that means exempt from the overtime requirements of the FLSA, or if they are non-exempt. And doing an analysis to determine whether someone is exempt or non-exempt has to be done on a case-by-case basis based on the duties performed by each individual employee, not based on a job title. For the most part, many job titles, it may be obvious, but what you will have to do is look at each of your employees and determine individually if they should or should not be exempt. And quite frankly, most employees should be non-exempt. Exempt employees typically are left to the higher level, for lack of a better word, bosses, the CEOs, the managers, possibly the supervisor, but any lower level employee typically, more often than not, will be considered a non-exempt employee. So my quick guidance here, takeaway, initially, I want you to assume that all your workers, except for possibly the CEO or the founding president, is non-exempt. And as such, they should be entitled to overtime pay for 40 hours or more worked in a work week. And in California, it's more than 8 hours in a day. And as I said, higher level employees may be exempt if certain criteria are met. For the exempt employees, they must be paid a salary. Exempt employees cannot be paid on an hourly basis. And a salary is defined as a predetermined amount that is not subject to reduction because of variations in the quantity or quality of the work performed. If someone makes $50,000 a year and halfway through the year you're deciding they're not doing a great job, you can take disciplinary action, but you can't just decide to reduce the amount they're making, or if you do, then they're considered not to be on a salary and you have to deal with different types of overtime payments. Currently, the law still is that an employee must make at least $455 a week. That's a little over $26,000 a year to be considered not exempt salaried. And deductions or docking from salary are pretty limited. If you have any questions about that, I can always tell you some of the limitations, but for purposes of this presentation, I want you to really think that you should not be planning on deducting or docking an exempt employee's salary. So as I said, exempt employees are the higher level employees, and they're known under the legal test as either executive, administrative, and professional, some outside sales, commission employees, and certain computer-related workers. And the two I want to focus on here are executive and administrative, as those are the most common for small companies. And executive employee is what you think of an executive. He or she, the primary duty, his or her primary duty is the management of an enterprise or the management of a department in your organization. And importantly, this individual must direct the work of 2 or more employees, either directly supervise or at least have influential decision-making power regarding hiring and firing or promotions or other changes of status. Now, the administrative is slightly different, and where this gets confusing is there are lots of job titles that have administrative in them, such as an administrative assistant. But an administrative assistant, more likely than not, is not considered an administrative employee and therefore is not exempt. Under the law, an administrative employee is someone who performs work directly related to the management or general business operations of the employer and whose primary duty includes the exercise of discretion and independent judgment with respect to important matters at the workplace. So if the employee only follows an instruction manual and doesn't really make a lot of independent decisions and utilize his or her discretion, that employee is not considered an administrative employee and thus is not exempt under the Fair Labor Standards Act. A few others, as I said, outside sales. If someone whose primary duty is making sales or obtaining orders which are customarily and regularly engaged away from the employer's base of business, that employee could meet the outside sales exemption. Another exemption we don't see too often is a highly compensated employee. If that employee makes over $100,000, he or she could be considered exempt even if he doesn't perform other exempt type duties. Certain high-level computer workers, typically not someone at a help desk, but someone who does more programming, design, development, and analysis. And finally, someone in the retail sales commission. If you work in a retail or service establishment and more than 50% of your earnings represent commissions, there is a good chance you could be considered exempt from the overtime requirements with that job function. And I just wanted to throw this out here for you so you have it on a slide of what you need to keep in terms of record-wise. And you see there's many more records you need to keep for a non-exempt employee when you're determining how many hours they work every week and if you need to pay them overtime and when they clock in and when they clock out. For the exempt employees, it's much less. And just not to get too much into my scary mode here, but I just like to throw out these statistics so you know the seriousness of complying with these laws. In the past 6.5 years, the Department of Labor has engaged in 150,000 investigations, and of those, over 2/3 there were findings of violations, and that amounts in total to almost $80 million in civil penalties and $1.5 billion in back wages. So there's a lot of back pay that has to be paid for misclassification or other types of wage and hour violations. And as I mentioned, the DOL has spent a lot of time and a lot of money combating improper classification of employees who are masquerading as independent contractors. And I mentioned this earlier, but when there is a FLSA violation, back pay is the primary relief that is sought, but also there's liquidated, which means double damages. Some states, Maryland in some cases, has triple damages. And it's also possible there could be punitive damages if it's found that the wage and hour violation was intentional. So for the last few minutes here, I just want to go through some common questions and mistakes that I hear day in and day out from clients that I deal with, that I want you guys to be proactive and be able to address these mistakes before they occur so that they don't actually become mistakes. And one thing I hear all the time that's difficult from various clients is that they allow employees who report to work early to start work prior to the time that they clock in for the official start of their shift. So let's say someone works primarily on their computer and they're supposed to start at 9 a.m. They get at 8:40 while their computer is loading up and they're waiting to log in. They do some paperwork that's laying on their desk, and they think, this will be good. I'll just get it done before I clock in. Again, theoretically, that's great for your company. That helps you, the employee, get started on the right foot that day. But unfortunately, that's a wage and hour violation. The FLSA mandates that you be paid all hours worked for all work performed. So what you want to do is you need to implement an off-the-clock policy and make certain that employees know that they must account for all of the time they are working, and that it's impermissible for employees to clock in early. Again, I have a separate slide just to say this again. Employees must be paid for all work performed, even if it's not expressly authorized by the employer. So if you find this occurring, you need to speak with your employees, possibly discipline them, However, you cannot say, oh, you know what? You did work before you clocked in. I am not going to pay you for that time. You should know better. That'll teach you. That is not a proper disciplinary action. You could suspend them, you can terminate, you can write them up, but you must pay for all work performed. Similarly, employees almost all have smartphones now, and when they're home, if they're answering business emails or talking on the phone with their supervisor or with a client or with anyone related to the work, that is working time. And you'll need to come up with some sort of creative solution for them to account for that time so that they're paid. If it's a one-sentence email that says, thanks, I'll see you tomorrow, that will be known as de minimis, and that's not likely compensable. But anything more than that, the time adds up. And if this starts happening more than once or twice a week, you do need to account for this time. Similarly, work, eating lunch during work. What sometimes employers have is, automatic, you're not paid for your half-hour lunch break. However, similar to employees who come in before work, an employee might think, you know what, I can still catch up on some work emails or do things while I'm working, as you can see in the picture we have on the slide. But please remember that if an employee works at all during lunch, he or she needs to be paid for the entire lunch period. It cannot be an unpaid period. So you either need to allow employees to get paid for the entire time or strictly enforce a policy where no work can be performed during lunch. Specifically, I just wanted to throw this in there for our California clients on this webinar, is under the Fair Labor Standards Act, rest periods are actually not required, but in California, there are specific requirements here that for non-exempt employees, there must be a 10-minute rest period somewhere between the third, 3.5, and 6th hour of the shift, and then an additional 10-minute rest period for shifts more than 6 hours, and then an additional 10-minute rest period for shifts of more than 10 hours after that. I had mentioned this quickly before, and I don't want to spend too much time on it, but again, an employee's overtime rate is not simply 1.5 times their hourly rate. All forms of discretionary earnings must be included in an employee's regular rate of pay. And if an employee works in 2 or more positions for which different wage rates are paid, a weighted average must be applied to determine the regular rate of pay for overtime purposes. Similarly, back to the question of whether an employee is exempt, if someone is quote-unquote a supervisor, but they don't primarily act as a supervisor, they don't have the power to fire, they don't supervise 2 or more employees, such as some assistant managers, they are more likely than not a non-exempt employee and entitled to overtime. A final thing that a lot of clients ask me is whether they can just give employees compensatory time off instead of overtime, and that's a fairly easy answer, and the answer is no. Private sector employees cannot give comp time to non-exempt employees instead of paying 1.5 times the regular rate of pay. So that's been really a nuts and bolts quick summary, as quick as I could do for you, of all wage and hour issues that you should be aware of, at least at the tip of your head, at the top of your head, knowing knowing that there are issues that you should be aware of going forward. My goal here was to at least make you cognizant and aware of those issues, so then you could reach out to someone and get further support from a legal perspective, because I don't expect you to have all the answers. I just wanted you to be aware of the issues. But now that you're aware of these issues, I want you just to take these few small steps at least away from this presentation with you and keep them in your back pocket. Make sure you have a system in place to keep accurate records. Make sure the applicable minimum wage, A, you know it, and B, you know what 1.5 times that wage is, and you know how to apply the proper overtime rate to all non-exempt employees. have legal counsel review classification for exempt and non-exempt status, and review your independent contractor classification to determine if they are accurate. If there are classifications mistakes, some clients ask, oh, we don't want to tip our hand, maybe we should wait for a while, and you usually have to come up with a creative time where you want to implement these changes, but I wrote for the purposes of this slide, you'd like to correct them immediately or at least as soon as possible so the back pay and back wages do not accrue. In some states, such as New York, you can go back 6 years for all your back wages. So every day you have misclassifications, your liability is accruing. And overall, basically everything Kara talked about and I talked about are really just several of the numerous employment law issues that are faced by small businesses and startups each and every day. It really would be a good business decision for you to hire legal counsel that's experienced in employment law. Probably not the same counsel that maybe helped with the formation of your business or some other aspects of law that dabbles in employment law. It would be better to get someone who really has a lot of nuts and bolts experiences to really guide you as you grow and expand from an employment perspective in order to avoid these major costs and penalties that Kara and I both explained to you. And we have a blog, it's called the Employer Defense Report, where we write about these issues all the time. It really could be a good reference for you and your companies as they move forward. So feel free to check it out. You can subscribe for free. We send an email every time a new article is posted, and it could be really a good resource for you. In addition, another resource for you are these exact webinars. The next one is in a month on May 24th, and it's about the interesting topic of recurring issues in the workplace as they relate to marijuana and drug testing issues. And you can see the list of all the other topics that we'll be addressing in the coming months. And as Kara mentioned, we will make this, we can make the recording available to you and the slides available to you. And feel free, here's our contact information. You can write down our phone number and our email addresses, and we would love to answer any more questions or help you out going forward. And it really has been a pleasure doing this webinar for you.
If anyone has questions now, they want to just post into the chat function, feel free to do that. We'll hang on for a minute or two to see if any come in. Otherwise, as Jordan mentioned, please check out our blogs and our future webinars, and we hope that everyone found this as informative as you were hoping to find it. We appreciate your participation today. Okay, well, with that, we'll stop the recording, and hopefully everyone will participate, and we'll talk soon for future webinars. Everyone have a great day. Thank you. Bye-bye.
Thank you.